Okay, so let me get this straight. Chris Coons just sat in front of Trump's federal judicial nominees, people about to get lifetime appointments to the federal bench, and asked them one of the simplest constitutional questions there is. Can Donald Trump run for a third term? And the answer he got back, I am not making this up, was that this strikes as more of a hypothetical. It is not a hypothetical. The 22nd Amendment is 6 sentences. Plain English, ratified in 1951. And these are the people about to put on the robes for life. So watch this clip, then I'll break down exactly how bad this got. Hit subscribe right now so you don't miss it.
Senator Coons.
Thank you, Chairman Grassley, and to each of you and your families, congratulations. And thank you for raising your hand to serve and in some cases continuing to serve the public.
Thank you.
Mr. Mark, if I might, just tell me about the 22nd Amendment. What does it provide?
The 22nd Amendment, Senator, my career has mostly been in criminal prosecution. I haven't had an opportunity to use that one specifically.
Anyone able to help on the 22nd Amendment to the United States Constitution?
Well, Senator, I believe it is the amendment that deals with a 2-term limitation on
Correct.
the service
It
of the
states
president.
no person shall be elected to the office of the president more than twice. Mr. Mark, is President Trump eligible to run for president again in 2028?
Senator, without considering all the facts and looking at everything, depending on what the situation is, this to me strikes as more of a hypothetical of something that could be.
It's not a
raised.
hypothetical. Has President Trump been elected president twice?
President Trump has been certified the President of the United States 2 times.
Is he eligible to run for a third term under our Constitution?
I would have to review the
All I need to
actual
tell you
wording of
is
it.
the language of the constitutional amendment that makes it clear that no, he is not eligible to run for a third term. Anybody else brave enough to say that the Constitution of the United States prevents President Trump from seeking a third term? Anybody willing to apply the Constitution by its plain language in the 22nd Amendment? Nobody. All right, let's move on. Mr. Coons, what is res judicata? How does it apply?
It's a judicial doctrine that prevents a judgment that has been, in one case, applies to you can't go into court after a final judgment in one case and have it and litigate the same things again.
How is that distinct from collateral estoppel, which precludes litigating the same things?
Res judicata, one involves the same party, the other involves the same things.
And what's a requirement for these two doctrines to apply?
Notice, opportunity to be heard, final judgment of a court of competent jurisdiction.
Anyone disagree? If I might, Mr. Coons, is it pronounced the same way mine is? Or
Yes, it is.
Coons?
Yes, Senator.
My family's name was spelled that way when we came to the country. So, you were one of 3 judges on the panel in Alexander v. Trump, where the president was suing the Pulitzer Prize Board for defamation. When did your work on that case begin? When were you assigned this case to decide?
I first learned of that case in approximately January of 2025.
Not when the briefs had been filed?
No, Senator. The way it works in our court is we are not assigned cases when the briefs are filed. Once the case is ready for disposition, the clerk randomly assigns it to the judges in the court.
And when did you first speak to Senator Scott's office about your interest in a district court seat in the Southern District of Florida?
I mean, I've had many conversations with Senator Scott's office. The one about an interest in the Southern District of Florida, I believe, was in November of 2024. I don't know the date, but it's in my Senate Judiciary questionnaire.
And when did you release the opinion ruling President Trump's favor in this matter?
So I learned of the case in January of 2025, and the opinion was released in, I believe it was February 12th, 2025.
That's correct. So you issued an opinion where one of the litigants before you was the president and in favor of the president while you were in active conversation with the senator's office about seeking a federal judicial appointment. Is that correct?
For a position I did not, in fact, get, Senator.
How did you end up in front of me today?
It's a different position, Senator.
Did you consider recusing yourself from that particular decision?
No, and the canons that govern us in Florida, Senator, as I believe this committee has previously heard, it did not call for me to recuse myself. I did not have an interest in the litigation. and none of the bases called for recusal, and the Florida Supreme Court instructs us, the appellate judges, that we are not to recuse unless one of the bases in Canon 3 exists.
Does the Florida canons not require you to recuse if one of the parties before you has an interest that could be reasonably concluded by any common citizen to cloud your judgment on that matter?
Senator, I disagree with that characterization. I had not heard from the White House until after the opinion was final. I had only spoken.
When did you interview with the White House counsel's office?
At the end of February of 2025. I don't know the date, but I believe it's in my Senate Judiciary questionnaire.
Thank you for your testimony on that matter. Mr. Hendershot, if you would just take a minute and talk me through again how collateral estoppel and res judicata are different from each other.
So I'm not sure I can improve much on Judge Coons. I think that often res judicata today is used as sort of a catch-all term, but generally I think the difference is between claims and claims that may have not been brought but could have been brought potentially.
Right.
So collateral estoppel and res judicata is more a thing actually decided, as the Latin would suggest.
Thank you. Do you agree that judges should not be influenced by external pressure to rule in any particular way?
Yes, Senator, I do.
President Trump stated March of this year at a public event, quote, "We have rogue judges that are criminals. They're criminals, what they do to our country, the decisions they hand down and hurt our country. Is it possible for a judge's decision to be correct as a matter of fact and law, even if it differs from the president's desired outcome?"
Senator, I want to tread carefully because of Canon 5 in terms of commenting on political matters. But in the abstract, yes, decisions can be correct, and any citizen can criticize what a judge has done. That is, I think, part of their right to speak.
Thank you.
So before we go further, let's just put the actual text of the 22nd Amendment up on the screen, because the entire fight in this hearing is about whether Trump's own nominees will read it out loud and apply it. Section 1, no person shall be elected to the office of the president more than twice. That's it. That is the rule. It was ratified in 1951, specifically to prevent any one person from holding the presidency indefinitely. There is no asterisk, no exception, no Trump-shaped loophole. And federal judicial nominees are supposed to be, the experts on this stuff. And watch what Mark does. He calls it more of a hypothetical. No, it isn't. A hypothetical is what happens if a sitting president is incapacitated midterm. The 22nd Amendment is settled law, ratified 75 years ago. Coons literally reads him the words. Mark still won't apply them. Then Coons opens it up to the entire panel. Anyone brave enough? Silence. 4 nominees, 0 hands raised. Now, to understand why the Hendershot situation is such a big deal, you have to understand how judicial recusal actually works. Federal judges are bound by the Code of Conduct, and the standard is not whether the judge personally felt biased. The standard is whether a reasonable observer could question their impartiality. That is a much lower bar. And the moment you are interviewing with an administration for a promotion, while ruling on a case involving that exact administration, you are no longer the impartial referee. You are an applicant trying not to upset the boss. So here's the Hendershot timeline. November 2024. He's already in conversations with Sen, Scott's office, about a federal judgeship. January 2025, Alexander V. Trump gets randomly assigned to him February 12th, 2025. He rules in Trump's favor. End of February 2025. He sits for an interview with the White House counsel's office. He never once recused. And his defense on camera was that the Florida canons didn't require it. And this brings us to the bigger principle on the screen: judicial independence. The whole reason Article 3 gives federal judges lifetime appointments is so they don't have to fear political retaliation. They are supposed to rule based on facts and law, even when that ruling makes the president furious. That is the entire job description. And in March of this year, Trump stood on a stage and called federal judges, his exact word, criminals. So when a nominee can't even confirm in plain English that judges are allowed to rule against the president, that is the test failing in real time. And then listen to how Hendershot answers. Can a judge's decision be correct even if it differs from the president's desired outcome? His answer? In the abstract. Yes, in the abstract. He had to qualify it. A federal judicial nominee sitting under oath couldn't simply say yes. That right there is the entire problem of this hearing in one sentence. And look, none of this is random. It's a pattern. 4 nominees, 4 fumbles, every single one pointing in the same direction. Won't apply the 22nd Amendment. Won't recuse from a Trump case while interviewing with the Trump administration. Won't say plainly that judges are allowed to rule against the president. It is like interviewing for a lifeguard job and refusing to commit to whether saving the swimmer is, actually required or just kind of preferred. The whole point of the federal bench is that nobody should ever have to ask. The independence is supposed to be baked in. And the Senate is about to confirm people who literally cannot articulate that on camera, under oath, in front of a working microphone on a Wednesday afternoon in 2026. And then we get to the part on screen, res judicata and collateral estoppel. I know that sounds like Latin homework, but stay with me because this is basic stuff. Res judicata means once a court has decided a case, you cannot drag the same parties back to relitigate the exact same claim. Collateral estoppel is the cousin doctrine that locks in specific factual issues already decided. Every law student learns these too by November of their first year, and federal judges apply them constantly. So when a Trump nominee fumbles the basics on camera and the senator has to step in and explain it for him, that is not a small slip. So here is the line. Next time someone tells you this hearing was political theater, ask them one question. Why couldn't a single Trump nominee read the 22nd Amendment out loud and apply it? That is not theater. That is the answer. Hit like, subscribe, and share this with someone who needs the full picture. I'll see you in the next one.